So I think some of the mistakes that we make in here in this chamber is sometimes we take far too long with legislation, and then other times we rush legislation. And I think that there is some really, really good positives in the work-life balance bill, and it's welcome. And there's lots of groups, as I had referenced before, like the Carers Association and other groups that are really happy to see this come forward. But this particular section kind of being inserted into it, I think is nearly unfair to the bill, for want of better words, but also as a lot of the queries and the questions that Deputy O'Reilly has raised, we should have the normal time to tease them out through, like, you know, pre-leg and committee stage and all the other stages. So I think it does need to be a separate piece of legislation. Obviously, that's not what's going to happen now, but I just want to make the point that I do see where she's coming from in relation to this, and how we should have the opportunity to interrogate this separately, because it nearly takes away from all of the really good things and all the really long overdue things that are in the work-life balance bill around, you know, leave for parents of sick children and everything else like that many people will be waiting for a very long time. And I think there is a lot of really very genuine questions there in relation to that, and I don't know, will we be able to kind of get the sufficient answers to them this evening, or is this part of it going to be reviewed? Is it being reviewed separately? Or I know there was a mention earlier of a 2 years review. Will that be built into it? And if there's any comments on that, thanks. Let's count Carla.
And thanks to the deputies for their contributions. I think, you know, deputies have spoken about the process, both in terms of the work we've done through committee on the original work-life balance directive, and of course the work that's been done on the right to remote working bill. And I'm aware that a very detailed PLS process was undertaken, and a detailed PLS report was published. I think just in terms of the amendments being brought forward today, we are implementing the recommendations of the PLS report. And I actually struggle to think how often I've seen such a clear implementation of a PLS report in legislation. So I'll cite recommendation 5. The committee recommends that code of good practice are quickly evolved so that once in place, refusals must be grounded in a stated policy from employers founded on these codes. The committee proposes the principles, number 6, the committee proposes the principles underpinning a reasonable code of practice should now be set out in law and allow the WRC to design how they should be applied in different workplace situations. We're doing both of those with this legislation. The committee advises that to accompany the primary legislation above with a WRC, and we're using the WRC code of practice to elaborate on and encourage reasonableness on the part of employer and employee. We're doing that. Number 8, the committee proposes legislation should mandate the WRC to draw up a code of practice in the first instance upon which the policies of employers can be based. We're doing that. And finally, the committee proposes that the legislation should align with the general scheme of a work-life balance and miscellaneous provisions bill. We're doing that. We are implementing the recommendations brought forward from the PLS on remote working and implementing it again in a way that, you know what, we've had discussions, Deputy Funchion, in terms of how much of a PLS has gone into a piece of legislation. I really think a lot of this PLS has gone into this piece of legislation. So I think it's just maybe worth setting that out at the start. There will be a 2-year review of this legislation, and I think that's important. We're doing a number of new and innovative things here, and this is an area of the area of remote working particularly is an innovative one. As Deputy O'Reilly said, some companies now offer it from day one, and that's a positive thing. But again, we're putting in place a statutory right to request it here. So there will be a review after 2 years, and as we know, that review will also look at potentially expanding the right of the rights of flexible working, which is the right for varied hours or a shorter working day, which currently, as implementing the EU directive, only applies to parents and carers. That will examine extending that further as well, which could be a potential further advancement of the rights of workers generally. And of course, it will look at the provisions of the 5 days, look at the uptake of DSGBV leave and see what changes need to be made there. So I just wanted to make those as a general point. In terms of the in terms of the 6 months, within which the right to request gets its statutory basis, that allows an assessment in terms of the needs of the employer and the needs of the employee. It may not be automatically available in every workplace from day one for a full understanding of can a request for remote working meet the needs of both the employer and the employee. It's also important to remember that the right can be granted after 6 months, but that doesn't stop an employee applying for it earlier. As we know, there's a number of weeks of an application process in which their application is judged. That can happen before the 6-month period of time, but the actual ability to take up the right kicks in after the 6-month period of time. And again, as I said, remote working is about balancing the employer's rights and the rights of the employee. And I think maybe on that point, it is worth maybe drawing up a comparison. And Deputy O'Reilly referred to the UK legislation where she argues part of the approach adopted there is better than the approach being adopted here. I think it's worth just looking, contrasting the UK proposals with our own. Our own proposals contain no statutory grounds for refusal. That was in the original piece of proposal on remote working, the 13 reasons why. Now we have no statutory grounds for refusal, unlike in the UK legislation where they've 8 statutory grounds of refusal. The Irish legislation contains an explicit legal obligation for employers to consider the employee's needs. That's part of the balancing test under the Irish law. That's not the case in the UK legislation. And also the Irish law contains no limits to the number of requests that can be made under the UK legislation. That's limited to 1 request per year. So I think in terms of the overall strength of our legislation, it stacks up well vis-a-vis what's being proposed in the United Kingdom. In terms then of some of the other specific points that were made, the definitions that Deputy O'Reilly spoke about, so the substantial adverse effect and the reasonable grounds, both of those will be fleshed out within that code of conduct that we've discussed earlier on, that will be brought forward by the Workplace Relations Commission. In terms of the ask of the location, look, some remote working requests will probably be granted in terms of also having reasonable access to the office if the employee is needed to attend in the office or attended in the workplace at some point. And I think in that context, it's reasonable for the employer to understand where the employee is based and will be proposing to undertake the work. In terms then just of the exclusions, and again, I suppose this has to be understood in terms of what this is. This is a right to request. It's not a statutory right to remote working, and we recognise that it is a right to request. As we know, not all occupations, not all industries or particular roles within an enterprise will be suitable or appropriate for remote working, and as such, there has to be some element of an exclusion provision in there. But again, that is something that can be looked at in that 2-year review that we spoke about earlier on.